whether it is going to be implemented in near future or any date is specified. So what stage it is? So you see, the multiplicity of labor legislations was always a problem and was always a challenge in India. If you look at a larger picture, there are about 44 central labor legislations. And you know, the labor is one subject matter which is included in the third list of the seventh schedule of the Constitution. That is the concurrent list. So there are three lists attached to the seventh schedule: central list, state list, and concurrent list. Labor is a subject matter in the concurrent list, and it means, as you know, both the central government and the state government can enact legislations. So there are about more than 40, around 44 central labor legislations are there. And nobody knows exactly what is the number of state labor legislations, because every state has come out with so many legislations. Some are specific to that particular state only. But there are certain specific legislations which are there in every state, like Shops and Commercial Establishment Act. Shops and Commercial Establishment Act is not a central act, it is a state act. So every state has legislated these shops and commercial establishment. We have also a Shop and Commercial Establishment Act, Kerala Shops and Commercial Establishment in 1960. So this Shop Act was enacted by subsuming Travancore Cochin Shop Act and Madras Shop Act. Prior to 1960, these two acts were operating in Kerala. So there are umpteen number of state legislations. It is estimated that it is about 150 to 200 state legislations are there. So you imagine a situation of a company operating in all India level. How many labor laws they have to follow? Central 44, state another 150. Real problem. Multiplicity of registers, multiplicity of returns, and many are duplication. If an inspector come, you show the register or records or muster roll kept under minimum wages, then he says, where is the muster roll under Payment of Wages Act? So every act, separate registers, separate returns, separate procedures, etc., etc. So it was a felt need how to codify these central labor legislations, so that how can the government make it easy so that it can be implemented by the business people, business community, understand and implement easily. See, if you look at the labor codes, the legislations contained in the labor code, it spread over a period of 1 century, about 100 years, because the oldest legislation contained in this labor code is the Employees Compensation Act 1923. Suppose it had survived one more year, we could have celebrated the century. See, and there was no effort from the side of the government to consolidate these legislations. So it was a felt need. So under these circumstances, in 1999, the Second National Labour Commission was formed So it was announced on 15th of October 1999 under the chairmanship of Dr. Ravindra Verma. Actually, Ravindra Verma is a Malayali, but he is an expert in the subject in the sense he was the central labor minister in the Morarji Desai's government from 77 to 79. So under the chairmanship of Dr. Ravindra Verma, Second National Labour Commission was formed. And there were so many references to this commission. This commission submitted its report after 3 years study to the then Vajpayee government in 2002. 29 June 2002, the report was submitted. So though there were so many reference points, so many recommendations, for today's discussion, we will confine to mainly 3 references, and we will see what was the recommendation of the commission in this regard. So the first reference point was submit recommendations. How can we codify these central labor legislations? Number 1. 2, many are very old legislations. So therefore, what are the reforms required in these legislations? Then third is, you see, a rough estimate of the people, the working class in India is calculated as 50 crores of people. So out of that 50 crores, 45 crores are in the unorganized sector. Only 10% are in the organized sector. They have ESI, they have PF. You look at the membership of Provident Fund, it is 5 crores. So there are about only 10 to 12% of people are only in the organized sector who is having social security measures, social security cover, etc., etc. But rest of the 45 crores of people, they don't have permanent employer. Many are not working in any establishments, organizations, institutions. They have no continuous job. So the third reference point to the commission was suggest ways and means how can we extend a minimum social security measure to these people working in the unorganized sector. So if you look at the report, actually the 80% is only consolidation. There is no change in the provisions. Only thing, yes, there are about 15 to 20%. There are changes are there, reforms are there, new things are proposed. But one confusion with so many people is that, see, suppose there is an amendment in the Act, it is easy to find out which is the provision which is amended. So here what they have done, they have put all this old and new together, just like it appears as a new bouquet. But actually, there are only 20% flowers which are new. 80% flowers are old, but it is mixed in such a way that it appears something as a new bouquet. But that's not the biggest problem. If you go through the codes, it's very difficult to identify which are the new, which are the old provisions. Now let us come to the recommendation of the Second National Labour Commission. So first, reference point was how to codify the central labor legislations. Actually, the recommendation of the commission was to codify it under 5 headings. That is wages, industrial relations, social security, safety, working conditions, and environment. So after 2002, actually up to 2014, the discussions were held at various levels by the governments. And finally, the government has decided to codify these central labor legislations into 4 headings instead of 5 suggested by the commission. So they have not made a very big change or something like that. What they have done, the government has done is, the first 3 has been kept as it is. That is wages, industrial relations, social security. The 4th one, that is the safety, and the 5th one, that is the working conditions and environment. So they were made into one code, and that is how Occupational Safety, Health and Working Conditions Code has come. So the central labor legislations were codified into 4 codes. Code on wages, which was passed in 2019, that is why it is known as Code on Wages 2019. Then Industrial Relations Code 2020, then the Social Security Code 2020, and Occupational Safety, Health and Working Conditions Code 2020. So these are the 4 codes which is going to be implemented. Now, before proceeding further, let us see these codes are at what stage. See, first of all, none of the provisions of these codes are implemented. But certain sections has been given, effective date has been given, because that is with respect to the formation of committee, because Central Advisory Board, because they have some work to be done prior to the implementation of the code, like declaring the floor wage, etc., etc. But otherwise, none of the provisions of these codes are implemented. But these codes has become the law of this country. That means what? It has been passed by the Lok Sabha, it has been passed by the Rajya Sabha, the President has given his assent, and it has been published in the Gazette of India. All the 4 codes has become the law of this country. Now, what is balance is the publication of its rules. So with regard to rules also, almost all work is completed. That is, the preliminary notification has been taken out, calling for suggestions, objections, improvements, and all those things are considered. Probably there is one rule that is all these rules, the Parliament need not pass, but it has to be kept before Parliament for 30 days. And there may be a discussion. So that process, we do not know what has happened, but otherwise all other formalities has been completed. And it has been declared in the code that the day on which the final notification of these rules will take place, on the day the rule as well as the code will come into effect. So that is the stage. Now, coming back to our state. So each state also has to make rules. Certain things state has no role. In some of the these authorities which were given to the states in this code, it is taken away actually. For example, see, you all know that Industrial Employment Standing Orders Act 1946. It's a central legislation. That legislation is applicable to all the establishment where 100 and more than 100 workers are there. But in that central legislation, there was one clause that if state governments want, they can reduce that threshold. So Kerala has reduced to 50. Tamil Nadu has reduced to 20. Assam has reduced to 20. Rajasthan has reduced to 50. So I was telling that some of the rights are taken away. So in this code, that 100 has been raised to 300. Now, whatever the companies are fortunate to have a standing order, yes, even if it is less than 300, it will continue, because under section 30, subsection 11 of the Industrial Relations Code says all certified standing orders, even if their number is less than 300, it will be deemed certification. But in future, no company which is having less than 300 workers will not get the standing order certified. And coming back to the point which I have told you, that yes, when that act was enacted, the state governments were given a power or authority to reduce the threshold number. So that is also taken away. Now state government cannot do anything. They cannot reduce the threshold from 300 to any other lower number. So these four codes, though we were hearing that 44 central labor legislations are subsumed, it is going to disappear, etc., etc. Actually, what is subsumed, what is going to be repealed is 29 central labor legislations. Four in Code on Wages. Code on Wages will subsume 4 central labor legislations. One, the Payment of Wages Act 1936. Second, the Minimum Wages Act 1948. The Payment of Bonus Act 1965. And the Equal Remuneration Act 1976. So these are the 4 central labor legislations which are contained in the Code on Wages. So 4. The next code is Industrial Relations Code. It will subsume 3 legislations, though it is only 3. Just because Industrial Disputes Act is one of the legislations contained in that code, it is so important, because among the acts, it is known as the Mother Act. As far as labor legislations are concerned, Industrial Disputes Act 1947 is the Mother Act. So Industrial Relations Code contains 3 legislations. One is Trade Unions Act 1926. Then the Industrial Employment Standing Orders Act 1946. Then the Industrial Disputes Act 1947. So all the 3 is going to be subsumed, and only Industrial Relations Code will be there. So 4 plus 3, 7. Then the next comes the Code on Social Security. It contains 9 central labor legislations. It contains the oldest act, starting from the Employees Compensation Act 1923. The senior people attending this seminar, this webinar, may not be very familiar with the Employees Compensation Act. We are all familiar with the other name, Workmen Compensation Act. Because when the act was made, its name was Workmen Compensation Act, and it remained so up to 2010. In 2010, the name was changed through an amendment. But The biggest change as far as the Workmen Compensation Act is concerned is not the change of name, but this is one point all of us should be very thoroughly understand. That is, up to 2010, in the Workmen Compensation Act, there was only provision to pay compensation. But in 2010, along with the change of name, the biggest change has come. That is, the employer will be responsible to make all payments with regard to the treatment. Of course, compensation could be calculated and you can reasonably assess what will be the compensation. But in today's condition, suppose it is a serious accident, it can run into lakhs and lakhs. But yes, 2010, that change has come. Not only compensation, the employer is liable to pay all the expenses towards treatment. And one peculiarity of this Employee Compensation Act, probably everybody know, for which even no establishment, no organization is required. There is a schedule. In that schedule, if some job is described, if that job is there, if somebody engages a person for that job, yes, if anything happens, he as an employer will be responsible too. For example, Kerala has added many things. Two examples I will tell you. One is Mahod, Anapapan. Suppose in Nambudiri Silam, if the Ana kills the Papan, the Mahod, Nambudiri has to pay the compensation for which no establishment is required. Another which is added by the Kerala government is Kakkavaral. You take somebody to help you to the river to collect this Kakka, and suppose he drowned, you have to pay compensation. Not only that, you call a person to your house for the maintenance, repair, or construction of your house, and suppose he falls down from a height of 12 feet, you have to pay compensation. Not only you have to pay compensation, you have to incur all his expenses. So many are, fortunately, both the worker and the employer is not much aware of these provisions. Therefore, things are very smooth. Now, let us come back. Social Security. 9 legislations, starting with Employees Compensation Act 1923. Next one is Employee State Insurance Act 1948. Next one, Employees Provident Fund and Miscellaneous Provisions Act 1952. Next one, Employees Employment Exchange, Compulsory Notification of Vacancies Act 1956. Then Maternity Benefit 1961. Payment of Gratuity 1972. Then Cine Workers and Cinema Theatre Workers Cess Act 81. Then comes Building and Other Construction Workers Cess Act 1996. And the last one, that is 2008, that is Social Security for Unorganized Workers. So 9. So 4 plus 3, 7, 7 plus 9, 16. And this last one, Occupational Safety, Health and Working Conditions Code, the biggest number of labor legislations. The reason I have already explained to you, because actually the recommendation of the commission was to make it 2 codes, but government has decided to make it 1 code. That is why it contains the biggest number of, largest number of legislations. So it contains, starts with the Factories Act 1948. First, all the 3 organized sectors, that was the organized sectors which was available at the time. Factories Act 1948, Plantation Labor Act 1951, Mines Act 1952, working journalists and newspaper employees, conditions of service 55, working journalists and newspaper employees, fixation of wage rates 58. Then comes BD and cigar workers establishment, then the motor transport workers, then the contract labor, then the Sales Promotion Employees Act, then interstate migrant workmen. Then comes the cine workers and cinema theater workers, conditions of service, then building and other construction workers, conditions of service, and dock workers, health, safety, and welfare. So these are the 13 legislations which are contained in the Occupational Safety, Health, and Working Conditions Code. So therefore, this is the overall picture. These 4 codes is going to subsume 29 labor legislations, 4 plus 3 plus 7, that is 7, 7 plus 9, 16, 16 plus 13, 29. So, is there any real codification has taken place? What do the statistics say? Whether the real codification has taken place? Yes, real codification has taken place. Because if you look at a macro picture, these 29 central labor legislations were contained 1,232 sections. That has been reduced to 480 sections in these 4 labor codes. That means it has been reduced to 38%. So there is a real consolidation, there is no doubt. But if you take the Occupational Safety, Health and Working Conditions Code alone, it is much more, because it was all repetitions. Factory, plantation, mines, working journalists, BD and cigar workers, newspaper employees, sales promotion people, contract workers. In every act, there are provisions. Working conditions provisions are there, leave provisions are there, safety provisions are there, welfare provisions are. So almost it was all repetition. That is why 633 sections contained in these 13 legislations has been simply reduced to 143. That means it has been reduced to 23%. So this is the overall picture of the labor codes. This is the current status. These are the legislations which is going to subsume. Now, we will come to our subject, Provident Fund, ESI, Gratuity. Now, you see, actually, if you look at the provisions of the code, there are definitely some changes with regard to the Provident Fund. There are some changes with regard to ESI, few changes with regard to gratuity. But the major portion of the Provident Fund and ESI is not touched. Because look at the Provident Fund. The Provident Fund Act 1952, the full name is Employees Provident Fund and Miscellaneous Provisions Act 1952. That act has no rules. It is operated through 3 schemes. That is Employees Provident Fund Scheme 1952, Employees Pension Scheme 1995, and Employees Deposit Linked Insurance Scheme 1976. All this comes in the Social Security Code. And the last section of that Social Security Code says that for 1 year, we will not touch these schemes. Only Act is going to be subsumed with some changes. But as far as the major portion of Provident Fund, that is the 3 schemes, Employees Provident Fund Scheme 1952, Employees Deposit Linked Insurance Scheme 1976, and Employees Pension Scheme 1995 will remain intact for 1 year. Provident Fund Act has no rules. Act plus 3 schemes. So there is no question of repealing the rules because there is no rules at all. It is operated not through the rules but through the schemes. Now, what are the changes in the Provident Fund Act? The first thing is, you see, when this Provident Fund Act was enacted in 1952, it has got a schedule. Even if you have, it started with 50 people at that time, and 3-year infancy period was there, everything in between, everything is taken away, and from 1990 onwards, day one coverage has come. When it was started, there was a schedule, and in that schedule, 6 industries like the steel, cement, tobacco, engineering products, 6 industries were added, and the Provident Fund, the act was implemented, and one by one, the government, by giving 3 months notice, it can add industries to the schedule. Because at that time, so many industries which we are seeing today, it was not there. IT industry was not there. Even construction industry, it was included in the Provident Fund only in 80. 31st October 1980 was only it was implemented. So there was no IT, there were tourism, so many industries were not there which we are seeing today. So one by one it was all added. Today many are not familiar with this. Many do not know there is a schedule because almost everything is included. So when you start employing 20 people, you never look at whether this is there in the schedule or not, because almost everything is. But during the history, there were a lot of fights. See, one such fight which was very well known, which just came up to the Bombay High Court was, see, an inspector went to the mineral water industry also. At that time, it was a new industry. We never thought that we'll buy the water in bottles and drink. So one inspector went to the mineral water factory. And we has counted as about 35 people are working there. Then he asked the employer, where is the Provident Fund? No, sir, there is no Provident Fund. You know why? There are more than 20 people are there. Yes, more than 20 people are there. You are aware of the provisions, but why you have not obtained a code number and covered these people? He said, my industry is not in the schedule. No, who told you it is not in the schedule? There was a big argument, so he issued prosecution notice. He also challenged. It went up to the Bombay High Court. So High Court referred the matter to the experts. So what was included in the schedule was aerated water. So the question was, is the aerated water and mineral water same or different? Experts gave the opinion that aerated water is something different. That is soda, cola, etc., etc. The composition and manufacturing of mineral water is something different. Both are 2 different products. So the prosecution was quashed. So there were many instances. Now, the first change which is going to happen with regard to Provident Fund, when the code comes, is that the schedule is going to be removed. There will not be any more, this schedule will be there. No question whether it's a new generation industry. You cannot look at the code and find out whether it is there or not. The only criteria is that if you employ 20 or more than 20 people, yes, your establishment is to be covered. But who are these 20 people? Who are to be counted for counting these 20 people? That was another big dispute. So some clarity has been brought in these provisions. You see, there were few very important cases. Even in Kerala High Court, there was a very big case with respect to the Arun granites. Many of you may know. That is, it was with regard to ESI. It's about, it is saying ESI, when you start employing 10 people, you have to. So for this, whatever I am telling now, it is for the common for ESI and PF. So there were 8 workers and 2 partners. ESI authority said 8 plus 2, 10. Now you start implementing. They said, no, we are partners. Means we are employers. We need not be included. So it became a dispute. Finally, the matter came up to the Kerala High Court. So simultaneously, at various parts of the country, similar cases has come up with regard to ESI and Provident Fund. Kerala High Court, similarly, so many other high courts also held that if they are partners, they need not be counted. Because the firm and the partner cannot be 2 different legal entities. But another case has come. 19 people and 1 managing director. Matter again went up to higher courts. So there the court said the managing director and the firm can be 2 different entities. There are so many establishments where the paid managing directors are there. Chairman will be the owner, but managing director will be a paid managing director. So the court said it can be 2 different legal entities. Then what is the criteria to be applied? The criteria to be applied is if the managing director is paid, drawing salary, he should also be counted. He may not be covered once the code is taken because he is out of the coverage area, but if you want, you can cover him. But for counting 20, everybody is to be counted. So that is one thing which you have to be very clear, whether it is contract labor, casual labor, temporary worker, casuals, engaged through the contractor, whatever it may be. You have to count everybody in that organization to count the 20. So that is for the purpose of to decide whether the establishment is to be covered or not. But once it is covered, then whether each and every member is to be, individual worker is to be made member of the fund, that is the different criteria. For to decide whether to enroll that establishment or not, yes, everybody is to be taken. If 20 people are there within your compound, yes, they may be engaged through contractor, they may be direct employees, they may be part-time employees. You are responsible for enrollment of your establishment under the Provident Fund. So this is one change. Now, another change. See, in Provident Fund, it becomes applicable to an establishment or any organization which is in the schedule once you start employing 20 or more than 20 workers, 20 employees. Now, you have only 15 employees, but you want to cover for many reasons. One reason, both employer and employees are agreeable. Sir, there are a lot of benefits. Suppose something happened to us, our wife and children will get pension. That is angle from the workers or employees angle. In some occasion, employers also want to cover. Because if you want to take a contract from a public sector company, maybe a small work, a small fabrication work, unless you have Provident Fund and ESI code, you will not be issued with the tender form. So they don't want to take that risk. Because only exception from the Provident Fund and ESI for the principal employer is if they have independent code numbers, yes, then you are safe. Otherwise, whatever may be the circumstances, the coverage contribution of the employees engaged to the contractor is the responsibility of the principal employer. See, if you look at the history, up to 2002, the contractors were never issued a code number by the Provident Fund Department. If you apply, they used to give a subcode number. But subcode number means the applicant is the main establishment only. And they say, as per your request, for the administrative convenience, we are issuing a subcode number. That's all. From 2002 onwards, these contractors were issued with code numbers. Then, one of the first cases was in 2011 before the Madras High Court with respect to Madurai District Cooperative Bank. So Madurai District Cooperative they had some contractors, and contractor had independent code number. But the department did not agree. They tried to catch hold of the bank. Bank went to the High Court. Then one favorable decision from the Madras High Court in 2011 in the case of Madurai District Cooperative Bank is that if the contractor is having an independent number, then you cannot catch hold of the principal employer. So the logic, what the court held is that, see, you are issuing a code number to contractor. Whatever this principal employer has to do to obtain a code number, everything this contractor also has to do. Company's address, PAN number, partners address, number, PAN, everything. That means what? That means you are accepting him as a establishment. Then the relation is between principal to principal, established to established. You catch hold of him. Don't look at him. But again, one more case has come in 2015. Again, same Madras High Court. In the case of Brakes India Limited. There, what happened? Once they failed to recover the money from the contractor, they turned towards the principal employer. Then in that case, court again held, no, if he has got a separate code number, then you have no right to go to him and recover the money from the principal employer. But for all the principal employers, though this is the condition, for abundant caution, before you release the contractor's bill, please ask the contractor to submit the ECR for the last month. Electronic challan cum receipt. Then you are fully saved. Because you see, in 2009, the computerization has come in the Provident Fund Department. So that is the time we started giving the 3A and 6A in CD. The senior people may be remembering. And 2012, it has become online. 2014, UN has come, Universal Account Number. So from 2012, once you remit the money, it immediately goes to the individual account. Not that you have to wait for the year end and then prepare 3A and 6A, then a long slip will come. What is your balance, etc., which was not required. So once you remit, the ECR will come. So earlier, monitoring was very difficult because the contractor will remit the challan and you do not know to whose account this money has been remitted. He may have contract in 5 places. In all the 5 places, he will give the copy. So today, monitoring is very easy. Though these are the positions, these are the court verdicts, as an abundant caution, please ask the contractor to submit the ECR. And suppose he is only working for you, yes, all the names are there. Suppose he is working for other firms, you ask him to mark, yes, 25 people are here, you mark that 25 people, give to me. You file and release his money, you are fully saved. So this is another very important thing. Now, coming back to the point. Suppose you had, yes, for a particular reason, maybe taken up by employees, or you want to get a tender form, there is no 20 employees, you want to get a code number. The provision is, yes, there was a provision for voluntary coverage. The only thing, all those documents, in the normal case, what are to be submitted, you have to submit, but added to that, you have to submit an additional paper. That is consent of the majority of workmen and the employer jointly. Then you can have the code number, voluntary coverage. But once that voluntary coverage is done, then you cannot come out. After some time, if you say, no, I have voluntarily covered, so I cannot be inspected. So it is not that statutely I was not liable to be covered. So you cannot punish me, etc. Nothing will work. And you cannot come out also. And as far as ESI is concerned, there was no provision for voluntary coverage. Now, when the code comes, one of the changes is that ESI will also have this voluntary coverage facility. It is coming with certain modifications. That is, I told you, once you cover voluntarily under Provident Fund, then you cannot come out. Now, this voluntary coverage comes with a modification. That is, first thing, the voluntary coverage, which is not there in ESI now, it is extended to the ESI also. Now, both, once the Social Security Code has come into place, yes, this ESI and Provident Fund both will have voluntary coverage provisions. But one change is, that is, there is a small window kept open. Under certain conditions, you can come out. It is not very easy. The conditions are, for the first 5 years, you cannot come out, whatever it may be. You have to continue. But after 5 years, again, if the majority of workmen and the employer decides that, no, enough is enough, we don't want Provident Fund, we don't want ESI, again submit the application from the joint application from the majority of workmen and the employer. You can come out after 5 years. But if during these 5 years, as far as Provident Fund is concerned, if you have touched on any day 20 workers, the matter is closed forever. Because the voluntary coverage on that day will become the statutory coverage. Similarly, here also ESI, yes, that provision is there. After 5 years, if you want, all of you decide you can come out, but if any one of the days, if you have employed 10 people, then you cannot come out. Because there also, the voluntary coverage has become the statutory coverage. So this is one change which is going to come. Now, another very, very important change. See, today, suppose a Provident Fund inspector comes to your office. How long he can ask for the contribution? Suppose you have not, either you have not obtained the code number or you have not covered certain employees. But what is the back period to which the Provident Fund can claim the contribution, interest, and damage? As of now, there is no limitation. They can ask the contribution from the starting of your company. The only savior is, that is 2016. In the case of Builders Association, Supreme Court said, okay, you go back to any period. But if you are not able to identify the beneficiaries, you cannot recover. But that is only with respect to Provident Fund. Because, see, the penalties are both the contributions, 12% interest, and there is a chart I will explain with respect to the damages. So this contribution and the interest will go to the employee. So you cannot say that, okay, employee, who is the employee? We do not know, no records, nothing is there. Okay, no records, nothing is there. You bring the money here. I will take that money. So that is the logic which Supreme Court said. That money you cannot take. And you have to identify the beneficiaries at the stage of inquiry. And if you are not able to identify the beneficiaries at the stage of inquiry, no recovery is possible. This is the Supreme Court decision in 2016 in Builders Association case. So today that is the case. You can ask to the back period any number of years. So now that is going to stop. In this new code, that is going to be limited to 5 years. Beyond which, no, you cannot go beyond, travel beyond 5 years. That's the last point. But as on today, yes, any number of years they can go. So this was a long-standing demand from the business community. The government has accepted it. And now in the code, it will get implemented. So what about ESI? Is it the same? ESI, this was the provision. They can also go to any number of years. But on 1/6/2010, 1st June 2010, there was an amendment in the ESI Act. And according to that amendment, the provision has brought in that they cannot ask beyond 5 years. So that it is already there. So in the Provident Fund, it is going to come. Another favorable provision as far as the employers are concerned. You see, suppose you make a default under the Provident Fund. By the way, what are the common violations under Provident Fund and ESI? Both are same. What are the common violations under Provident Fund and ESI? The violations are of 3 types. The first violation, which is known as or called as non-enrollment. Non-enrollment means you were to cover an employee as per his entitlement, but you did not cover him. Oh, he is a temporary worker. Don't cover him. He is a tea maker. Don't cover him. He is a super. Avoid. But you see, when the inspector comes, especially to a permanent establishment, he never asks the Provident Fund details and coverage details of your permanent employees. No inspector has never asked. He says, I want to go to canteen. Sir, what is the problem? You want to have tea, or we can ask him to bring here? No, I want to go to canteen. You please come with me. He goes, count the people. 1, 2, 3, 8 people are there. So when I come to the office, please show me the Provident Fund of these 8 people. Now let us go to the security cabin. Security officer. So where is the register? Yes. How many people are there? 18 people. Okay. Manager, when I come back to the office, I want to see the Provident Fund of these 18 people. When they come back, yes, 2 people are cutting the lawn. Who are they? Sir, they are temporary. They are these part-time workers. They come only 3 days in a week. So part-time workers, is there any exemption? No exemption for part-time workers. I want to see the Provident Fund. Then some ladies are sleeping. So where is their Provident Fund? So the big establishment, small establishment, everybody land up with the trouble. So the first violation is non-enrollment. That is, you were to enroll an employee, you did not do. That violation is known as non-enrollment. Then second violation, which is known as short payment. What is short payment? You have covered these people, enrolled these people. Even grass cutters, lawn cutters also you have included. But you are paying a salary of 10,000 rupees and you are remitting Provident Fund for 3,000 rupees. This is what is known as short payment. Because, okay, you can, that exemption is only for HRA, overtime, bonus, commission. So if you put out of 10,000 rupees, 25% straight away HRA, many commissioners will close their eyes, but beyond which it's very difficult. But 10,000 rupees salary, you remit only for 3,000 rupees? No. So that is called short payment. The third violation, which is known as delayed payment. You enrolled a person, you deducted his contribution, and you are supposed to remit it next month, you did not do. That is non-payment. So non-enrollment, short payment, delayed payments, these are the 3 common violations. For all the 3, both in the Provident Fund and in the ESI, punishments are same. So what are the punishments? Punishment number 1, according to the provisions of the Provident Fund and ESI, the employee's contribution can be recovered only from their current wages. If you do not recover, you pay the money. Only from the current wages you can recover. Suppose you don't enroll him, suppose there is a short payment, you pay the money. Employer has to pay both the contribution. So that is the first punishment. Second, from the day of avoidance to the day of remittance, you have to pay 12% interest. Then comes the damages. See, damages earlier, some discretion was there for the commissioners. But it resulted, wherever discretion is there, we know what is going to happen. Actually, there is an internal circular that you will not tell anybody. There is a printed format, 100% damages. Sir, somehow you have to save me 100% damages means 10 lakhs plus 10 lakhs. Then I may have to close down my company. Okay, man, I understand your position, but what can I do as a government servant? I have to go by the rules. Then he started crying, then so many discussions, etc. He says, okay, then so what is the benefit for me? So he has got an internal circular that take only 33%. He says, I will reduce to 50%. See, more than 17% more than what is internal circular is there. So this was what is going on. Not with all offices. There are in every department, there are very, very honest officers are there. We have recently witnessed one officer here also. Many people know who deals with a very honest officer. There are many honest officers who because they take decisions. They are not afraid. So the third, the government then what did they do? The discretion power is taken away. Discretion always create a problem. They have given a chart, a table. You look at the table, apply the table, that's all. No discretion at all. So what is the table? The table is depending on the delay. That is, suppose your delay or the non-remittance is for a period of less than 2 months. The damage is 5% of your assessed amount. See, the first, they will call for the 7A inquiry under the Provident Fund, or they will call for the 14B inquiry, 45A inquiry under the ESI. And the first thing is that contribution will be assessed. So assume that contribution is assessed 1 lakh. And the delay is less than 2 months. You pay 5% more, that is 5,000 rupees, close the chapter. Interest? Yes, that is there. But if the delay is 2 months has completed, but it has not completed 4 months, you pay 10% of this assessed amount. The next level is that is 4 months completed, but 6 months is not completed. Then you pay 15%. Once 6 months is completed, 6 months is touched, for per year 25% per annum. The only cap is that there is a provision, both in the Provident Fund and in the ESI, that the damage should not exceed the contribution avoided. That means within 4 years, it will become equal to the contribution. So this is the thing. Now, coming back to the point, suppose it is assessed, you have been given notice, and 10 lakhs is what the contribution from your side is assessed. You want to contest. So you want to contest means you have to go to the industrial tribunal established by the central government. Earlier it was not there. Beginning it was only in Delhi, then it came to Bangalore. Now in the Karshaka Road, yes, it is there. In Ernakulam, it is there. But if you want to contest and your assessed amount is 10 lakhs rupees, you have to remit 7.5 lakhs. Then only the case will be admitted. But the court has got discretion. Suppose prima facie, you can prove that there is a merit in your case, then court can reduce. Again, discretion. So that is removed. That 75% has been reduced to 25%. This is a good news for the employees, there is no doubt. Instead of 7.5 lakhs, you remit only 2.5 lakhs. But at the same time, the discretion of the court is also taken away. Now, if the court cannot make it 0. Discretion is taken away, but 75% has been reduced to 25%. So this is another change which is going to help the employers. Then there were 2 provisions in the Provident Fund. Many of you must have noticed. That is section 7B and 7C. 7A, you know, that is the provision for the conducting the inquiry. The Assistant Provident Fund Commissioner will conduct the inquiry and he will assess the amount. But there were another 2 provisions. If I said 2 useless provisions were there, that is 7B and 7C. What is 7B? 7B, you see, I told you the appeal lies with the Industrial Tribunal, Central Industrial Tribunal. But there was another provision, that is 7B. That is, after this assessment, you can ask for a review. That is 7B. But nothing has happened in the review because the same person is making the review. It is not appeal. It is not somebody who is above him and deciding can take a different decision. So usually nothing was happening. Because review, you need not pay any money, but it is done by the same person. So you know what is going to happen. So nobody was going, many were not knowing, many were not going. Suppose somebody wants to challenge, yes, they used to go to the Central Industrial Tribunal, that is Provident Fund Appellate Court. Then what is 7C? Another, if this is useless, another very useless provision. That is, there was a provision, okay, you conducted an inquiry under 7A, you assessed 10 lakhs, but after that assessment, within another 5 years, if you come to know in the same case there is some other lapse is there, again you can reopen the file, assess again some more money. So one good news is that 7B and 7C both are going to be discarded. The new code, it will not be there. So these are the changes which is with regard to the Provident Fund and ESI. I will share my PPT with you because generally I take either Provident Fund or ESI or gratuity, but now this is only with respect to only changes has been incorporated. So I don't have a separate PPT, but I will share the full PPT with you. I will send it to your office. You can take it from there. Then another change in the ESI, that is, you see, today, suppose non-enrollment, a case of non-enrollment. You did not enroll a person. He is working as a gardener. He went to the 3rd floor to put a flower pot there. He fell down from there. He died. Then the ESI people will come. Everybody will come. Why ESI people? So they will assess. They will find out how long this person was working. Oh, he was working for the last 5 years. So this is the contribution. What was his wages? Contribution assessed. Yes. Notice will be issued to the employer. Okay, employer has to pay the money. But what is the use for that person who has already died? There was no provision for giving him the compensation by the ESI. ESI takes the money from the employer. Because he is not covered and they say he is not entitled for any compensation. That really is an injustice. Now, in the Social Security Code, Section 42 has been incorporated, and accordingly, the entire benefit will be passed on to that victim if he is alive, or to his dependents in the case of his death. That's a good provision. There is no doubt. Then one more condition is there, that is, suppose you assessed with respect to that particular person who has died. The assessment is made, it is 1 lakh. His compensation is calculated, it is 1.5 lakhs. So earlier you could have paid 1 lakh and escaped. But today, if your assessed amount is less than the actual compensation to be paid by the ESI, that difference also you have to pay. But suppose the amount is assessed 1 lakh, and if the compensation is only 75,000 rupees, you need not pay anything extra. So these are the changes which is proposed in the ESI, Provident Fund and ESI. Gratuity, there is not much change. However, we will come to certain provisions. But before that, if few questions are there, we can take it up. Either you can put it in the chat box, somebody has to help, or you can unmute and ask, whatever way, whichever is convenient to the participants.
I think there is no question so far. Meanwhile, participants can post any queries in the chat box or Q&A box.
Either everything is clear or okay. So there is time. We will go to gratuity. See, gratuity, there is no major change. The calculation, entitlement, the formula to calculate last on salary into 15 divided by 26 into number of years. More than 6 months, that is to be counted as 1 year. Or if anybody has completed 4 years and 240 days, that is to be counted as 5 years and the gratuity is to be paid. And in the case of the death and disablement, the 5 year is not required. You have to pay gratuity if he has completed 240 days or 1 year. Otherwise, in all other cases, 5 years, but 5 years means now it was the court verdict. Now in the code, it has been made very clear that 4 years and 240 days is 5 years. Now, one more provision is added. Now we will come back. We will come to the provision, the new provisions as far as gratuity is concerned. See, one is that is there are certain occasions the gratuity can be withheld. The first condition is that he should get dismissed from the company. But all dismissals does not disentitle an employee to get gratuity. Suppose he is dismissed on account of continuous absence, he has to be paid gratuity. If it is because of a violent action, that is beating the supervisor or beating the co-worker, and on that account inquiry was conducted and it is proved, yes, his gratuity can be denied. Similarly, misappropriation, sabotage, yes. Third is, there is a provision to recover money from the gratuity. That is, if knowingly he damages some property of the company, and then on that account he should get dismissed. Inquiry conducted. And there was another provision, and that provision is still there. That is, if the employee get dismissed of any of the misconducts involving moral turpitude, he will not be entitled for gratuity. But now that provision, to implement that provision, now it is very, very difficult. Because moral turpitude, that's a very, very big word. Anything can be moral turpitude. So in 2018, please note this, in 2018, in the case of Bank of Baroda, the Supreme Court held, it is the decision of the Justice Kurian Joseph. Okay, if there is a charge of moral misconduct involving moral turpitude, you dismiss him. You are not telling anything. But if you want to, though there is a provision in the legislation, if you want to withhold his gratuity, then that misconduct simultaneously to be proved before a criminal court, then only gratuity can be withheld. So that means it is very, very difficult. So that is one thing. Second thing, a new provision is added for withholding gratuity. Again, that will also be very, very difficult, because in the code, one more provision for withholding gratuity is added. That is, suppose a person get dismissed on account of sexual harassment. But again, that provision, if that is by way of court verdict, yes, this is incorporated in the Act itself. That is, sexual harassment, if it is proved, you dismiss him. But if you want to withhold his gratuity, means that offense is to be simultaneously handled by a criminal court and he should get convicted. That means it will be very, very difficult. So these are the things which is with respect to the gratuity. But another major change is the incorporation of the provision of paying gratuity even if the employee completes 1 year if his appointment is on fixed term contract basis. You write that at the top, fixed term employment for 1 year, he is entitled for gratuity. Actually, there was a doubt among so many people. See, this fixed term contract was first notified by the central government on 16/3/2018 by way of a change in the Central Model Standing Order. A new category was added. There were only 6 categories: permanent, badali, temporary, contractual, etc., etc. 6A was added, that is fixed term employment. And the provision was that if the fixed term employee completes 1 year, he should be paid gratuity. Many had a doubt. No, this is a provision changes in the Standing Orders Act, but unless your Gratuity Act is amended, how can this be made effective? That was another doubt. So there is no place for that doubt, because the Gratuity Act itself says that on account of any other law, any other change or any other agreement, understanding, settlement, if an employee is entitled for a better benefit, yes, that can be avoided. Anyway, now that change has been incorporated in the Gratuity Act. Now that is going to come, that gratuity for fixed term employees on completion of 1 year. Then another change with respect to the gratuity is that, you see, what happened? Now, many companies, Gratuity Act become applicable to a company when it starts employing 10 workers or 10 employees. But small establishment, 25, 50, 100, 150, the establishments get closed down. And where the employee will go. If the employer is there, yes, he can go to the Deputy Labor Commissioner, file a case, something can be done. Establishment is closed, employer is also not seen. So in 1997, a provision was brought in the Gratuity Act for compulsory insurance. But it was a provision which is poorly implemented. One reason is that in that amendment, it was stated that whenever the state governments notify the same, then this act will become applicable to that particular state. 97 it has come. Kerala government, it was notified only 2017 and no strict implementation. Now, in the code, there are provisions for the strict implementation of this, because it is required. Because what these poor employees, what they will do after working 10 years, 15 years, company is closed down, employer is also not visible. So the provision of compulsory insurance is brought in again in this act, and it says all establishments having 10 or more employees has to have registration in the portal with respect to this gratuity, and the registration will be accepted only if you produce the insurance certificate. Only one exemption is that if you have 500 or more workers, then the government can exempt you from this provision and allow you to run your own trust for providing gratuity to its employees. So otherwise, nominations and all other things, there is no change in the Gratuity Act. So this is what I have to say. If few questions are there, we can definitely discuss. Unmute ചെയ്യണം സാറ്. Mute ആണ്.
Sorry, the mic is muted.
Yes, Salim, any questions there? Can you check, Salim?
No, there is no question till now. I think everyone is clear about it.
Everything is clear.
Sound is,
Everything is clear.
Usually, yes, this is a situation everywhere. Very few questions after my session because I take it slowly with examples.
Well, this PF, you're saying we have that 15,000 limit.
Yeah.
So is it in the new code also like that, or for the entire amount we have to pay the contribution?
No. See, the code, that part is not touched in the code. It is a separate thing. I told you it is in the scheme. Scheme is untouched. So that 15,000 provision is there. But very important thing, a very good question. See, the 15,000 is the limit, and the employer can stop his contribution on 15,000 rupees. Nobody can force it. That is one thing. Second thing, you can also contribute for the full basic plus DA. So let me ask you a question. Suppose your company was running very well. It was running profitably for many years, so that you were contributing for the entire amount of basic plus DA without the statutory limit. Because the statutory limit, you see, before 2001, it was 5,000 rupees. 2001, it was raised to 6,500 rupees. That remained as it is for another 13 years. From 1/9/2014, it has been raised to 15,000 rupees and still it remains. So the question is, your company was running very well. There was no problem. So you decided not to limit your contribution with 15,000 rupees. You were paying for the entire basic plus DA. But now, Corona, so many other things, your company is not doing well. You want to bring it down to 15,000 rupees. Is it legal? Is it possible? You search the entire Provident Fund Act, you will not find any provision for reduction. On the contrary, you will find the provision section 12 that nothing is to be reduced. But if you want, you can reduce. Because there was a big case which went up to the Honorable Supreme Court in 2011. The case name is Marathwada Grameen Bank case in 2011. So in that 2011, in Marathwada Grameen Bank case, Supreme Court held that at any point of time, the employer can reduce the contribution to the statutory limit. But if you had a specific agreement with anybody, because that will not be there. Usually, even if you incorporate the provision in the appointment order, you will be covered under the Provident Fund as per the provisions of Employees Provident Fund and Miscellaneous Provisions Act. Nobody will write that full basic plus DA, etc., etc. Nobody will write. So, Supreme Court said your commitment is you will pay the Provident Fund contribution as per the Act. As per the Act, yes, it is 15,000 rupees. You paid voluntarily, not based on any agreement with them. That was the practice which was going on. You also paid. So this is one thing which you can remember. Many of the Kerala state companies, see, you as an auditors of those companies, you may be knowing that 2018, CAG took an objection. Why the loss-making companies under Kerala government should pay the contribution beyond 15,000 rupees. Some cases, the court, somewhere it was manipulated, but see, the problem is that still that problem is there and many companies has reduced. The problem is that it affects not only, okay, it is a retirement kitty, but more than that, it will, the entitlement for higher pension will be lost. Because a person will be entitled for higher pension if his contribution from 16/11/1995 or if he joins after that date, from the date of joining to his retirement, if employer has contributed for the full basic plus DA without the statutory limit only, higher pension will be entitled. So many people are running here and there. So that is one provision. But once somebody is a member in the Provident Fund, after that, if he's a fresher and he draws more than 15,000 rupees, you need not take him in the Provident Fund. But once he was a member, yes, you appoint him for 1 lakh rupee, you have to enroll him under the Provident Fund. Otherwise, he should be an excluded employee. Excluded employees are not required to cover under the Provident Fund scheme. So who is the excluded employee? Number one, an apprentice engaged under the Apprentice Act 1961 is an excluded employee. Even if you want, you cannot cover him under the Provident Fund. Number two, if your company is having a certified standing order, and in that certified standing order, suppose there is a trainee or an apprentice other than the apprentice appointed under the Act, he is also excluded. Then the third exclusion is, suppose there is a person, he has lost his job or he has resigned or he retired. Take all the three cases. So the retired cases, suppose a person retired from the services of the company as per the rules of the company and he settled his account, Provident Fund account, then he becomes an excluded employee. He need not again cover under the Provident Fund. But suppose he is retired at the age of 58. So you said you continue for another 2 years. But if he is continuing without settling his Provident Fund account, you are liable to pay Provident Fund. And if you do not pay, it will be a violation. On a later stage, you have to pay both the contribution, interest, and damages. So if you want to make anybody continue or give a contract after retirement, suppose you want to give Provident Fund, yes, there is no problem. But if you want to make him exit from the Provident Fund scheme, ask him to go, settle his accounts, come back and join. Then you are absolutely free. Then another provision. See, this is in the scheme, there is section 69. It's a paragraph 69. Circumstances under which the accumulation in the fund is payable to a member. This is the marginal note of the paragraph 69. So excluded employees means a person who has settled his Provident Fund account as per 69(1)(a) and C. So A1 part we have told, that is retirement, settlement his account, he become excluded employee. Otherwise there is a provision. A person who has completed 55 years and he is unemployed now, he can settle his account, he become an excluded employee. But suppose even though he is unemployed, suppose he settles early, that is, either company get closed down at the age of 52 or he resigns at the age of 52, immediately he settles his accounts, then after 57, he get a job, then he is again to be covered. But 52, he resigned or his company got closed down, but he is wait up to the completion of 55 years of age. Then apply for closing down of his accounts, he became an excluded employee. You appoint him again, you need not cover him. Similarly, the person retired from the government, you have to be very careful. Suppose a neighbor is there in your company, he retired from the government, he says, sir, I was working as a clerk, I know computer, I know typing, I can work here, you give me 12,000 rupees. Anyway, I am getting pension. So 12,000 rupees more than sufficient. I want to do some work. Okay, you agreed for a salary of 12,000 rupees, whether he is to be taken in the Provident Fund or not. Many make a mistake. See, if you take him a retired government employee, less than 15,000 rupees you have to cover. Then you earlier told that a person retired, settled his account, you need not be. That is, if he is retired from the Employees Provident Fund 1952. A government employee is not a member of the Employees Provident Fund and Miscellaneous Provisions Act 1952. That is a separate Provident Fund. So even if a person retired from the government and you are taking him for a salary less than 15,000 rupees, yes, you have to cover him. So that is what paragraph 26 says. Once the establishment is covered, all the employees other than the excluded employee is required and entitled to enroll under the Provident Fund. The only exemption is that you cannot then, if he is an excluded employee, you cannot make apprentice. You decide, okay, we will cover him if suppose he get. No, you cannot do. The only exemption is paragraph 26(6), that by virtue of higher salary and he was never a member, you don't include him. But suppose you both the parties agree, yes, submit an application under 26(6) and you can enroll him as a member. Other excluded employees, if he's really become an excluded employee, you cannot cover. Yeah. if no other questions are there, we can conclude.
Chairman sir,
Yeah.
It's Salim, then we can conclude, Salim. If there is no
Yes.
questions.
I think there is no question. Thank you so much, sir, Vakichan Patasa, for the wonderful session on the labor laws. I think everyone is clear about the labor law, new rules and regulation for the PF and gratuity. Any further questions, we will disturb you in future also.
Oh, yes, you can always, you can share.
Thank you so much for the wonderful session, and thank you so much our chairman and our managing committee members, those who are attended, and senior members, those who are attended today's session. And also we have on second, we have study circle at our institute premises. Kindly attend the same. Thank you so much.
Sir, that PPT, if you can share to.
I will send all the 3 PPTs, you can share.
Okay. Yes, I heard that. So we can send to all the
Oh,
participants.
yes. And they can also contact me if there whenever
Oh,
there is a doubt,
yes.
I can clarify.
Thank you.
Only-
Thank you very much, sir. Thank
Yes,
you very
yes.
much.
Thank you everybody for the patient hearing. Thank you for giving the opportunity. Thank you.
Thank you.
Thank you, sir.